102 and 103, the people of the state of New York versus David Mairena, and the people of the state of New York versus Mauricio Altamirano. Counsel?
Good afternoon. My name is Michael Arthas. I represent the appellant, David Mairena. If I can possibly reserve 2 minutes for rebuttal.
You may, of course.
Thank you.
You're welcome.
In Herring versus New York, the U.S. Supreme Court describes summation as the most important aspect of advocacy. And when preparing a summation, one of the most important things that counsel relies on are the court's charge promises.
Counsel, how do you distinguish Smalling here for us?
So I think Smalling, I've looked at the briefs in Smalling. I've looked at the oral argument in Smalling. I don't believe that the harmless error issue is necessarily before the court in Smalling. So to the extent that Smalling is inconsistent with People versus Green, it's our position that Green should control. But the error itself is actually very similar between this case and Smalling. And what the error is that the court made a charge promise. Counsel relied on that promise during his summation, and then after summations, the court reneged on its promise, broke its promise, leaving counsel in a position where he was prejudiced in delivering the summation. Now, the rule that
So let's say you're correct. Let's say, assuming you're correct, that there was an error here. It seems the court would have two paths under which it could analyze them. Either it would be an error, a per se error, which means that once the error is committed, we're done. Some of the appellate divisions agree with that. First Department seems to go the other way and applies harmless error analysis. Where are you asking this court to go?
So I don't think the harmless error analysis is applicable to these kind of cases. And that's because the error that exists here, it's not amenable to that type of analysis. So
well, how is it any more or less amenable than, say, the decision to charge a lesser included offense without notifying counsel? Isn't that something that counsel would very much, or might, not would, but might very much want to address in summations?
Yes, I think the question then turns on reliance. So I think, just to be clear, the rule that we're proposing isn't that once the error occurs, it's absolutely a reversal. There would have to be reliance on counsel's part. When we say that there should be no harmless error analysis, we mean that the analysis shouldn't then turn to, was the evidence overwhelming, or would this person have been convicted anyway? But
reliance in any degree of materiality, or just reliance?
I'm sorry, I didn't hear.
Materiality as well as reliance, or just reliance?
I think it would be reliance. It would be reliance. So in terms of materiality, I think they go hand in hand. And I think what you could see is,
just so I'm clear, when you say reliance, does that equate to a reasonable possibility that you would apply under a harmless error analysis, that it would affect the outcome?
I don't believe so, because I think applying the reasonable possibility standard would then be, in a way, looking at the strength of the evidence otherwise. Mm-hmm. The reason we feel that traditional harmless error is not applicable here is because these type of errors, right, when we do traditional harmless error analysis, as the court knows, we take a trial error and we kind of cabin it off from the rest of the record and then look at the record and say, would this person have been convicted? That's not really possible when it comes to a summation, because a summation is really, it's a series of strategic choices. Mm-hmm. We can't look at the summation the way that the appellate division really did here, and Mr. Mairena's.
So if I'm trying to figure out what your rule is,
yes,
or what's the standard you say should be applied to this kind of error if there's an error, is what you're arguing that since effective assistance of counsel, our standard is meaningful representation, that there can't be meaningful representation if the summation, the strategic choices you're referring to are ones that depend on what the judge says, that the judge will or will not say to the jury. So as long as those strategic choices that may have some meaning in the presentation to the jury in the way the counsel is saying, this is how we marshal these facts, the evidence, this is what it means, this is the outcome that you should come back with. Is that what you mean, that somehow it affects the representation in a way that's meaningful?
Yes, and I think that's what the Supreme Court was getting at in Herring, which is that summation, since it is just a fundamental part of the right to counsel, we use those effective assistance of counsel standards to measure this.
How can you do that in a case like this? I mean, is there another context where we would say it's an ineffective assistance standard where it wasn't the counsel's decision to do this, it was the court's ruling that led to this action? Is there another ineffective assistance of counsel context where we've done that?
I'm not sure, but I think that what the issue here would be is that counsel's, it's not counsel, right, actively being ineffective. What's happening is counsel is making choices that then the court is rendering ineffective by its later decision.
That's a very different analysis, though, and even our traditional ineffective assistance of counsel doesn't really fit with that. But I think it goes back, and I think Judge Rivera was also getting at this. If you look at Herring,
Yep.
and Herring's really the only marker that lays it out, and they say, okay, denied a summation, but in Glebe they say, well, that's an error, but we never said that was, I think they called structural error. We never said that was per se. You may think that, but we've never said it. Really kind of signaling anything less than complete denial isn't structural error, I think. It can be read that way in Glebe. So this court has never really laid out a rule. So if we're getting to a fundamental error versus constitutional error versus statutory error, which would be the CPL, where do we ground a constitutional or structural error analysis? It seems to me a deprivation of a summation deprives you of that, and that's an assistance of counsel, right? And that's what the Supreme Court said. But less than that, what's the right we're grounding this in if we're going to go constitutional error or structural error?
I think that touches on what Judge Rivera had mentioned before about the meaningful representation standard. We can ask, was it a meaningful summation? And in Ashwell, this court said that counsel has a right to comment on every pertinent matter of fact put before the court. And I think I would.
So is it the
Yes.
same standard then if a judge is interfering, let's call it, with a counsel summation, either in limitations of time or in topics or repetitiveness, let's say? Would that be the same standard because the court is limiting counsel in that way?
I think that's different because counsel isn't actually being interfered necessarily with the opportunity to comment on something. If it was affecting counsel's ability to comment on a pertinent matter, then yes, I think it would touch on that standard. I would push back a bit because I think in Green, I think that this court actually did address this kind of error and did not apply harmless error, just simply said that because counsel had premised his summation on the charge promise, it was prejudicial.
Isn't it a way to look at Green because of the nature of the error there, that you effectively denied that party's summation? Therefore, it's Herring. But less than that, for example, let's say justification. I tell you you're going to get a justification charge, you only sum up on justification, and I say, you know what, you're not getting that, I'm not letting you reopen. Have I effectively denied you a summation in that case, which is Herring? But less than that is not denial of a summation. You'd have to find a right to an effective summation, which is, I think, kind of what we're talking about. And that we have never done, because I think Green, you could fit into the first category. But this isn't really Green, so where is it? And what right is it based on, if we can't anchor it in Herring?
I say that my time, can I respond
Of
to that?
course,
Thank you.
please.
So I think that this is actually a very similar error to Green in the sense that here, Mr. Mairena was effectively denied the opportunity to contest what the element of manslaughter was going to be. And when we really look at what the error is that occurred here, counsel was misled into giving a summation here that was actively prejudicial. He was led into presenting inconsistent defenses, which may have undercut the self-defense claim. He highlighted the autopsy pictures and graphic testimony. That was all in reliance on the court's promise.
I read his summation, and I thought, this is, you know, he does this one thing, but then he says, okay, now I'm going to get to my main summation, which is justification, really. And given the proof of this case, I mean, that made sense. But this is kind of, he touches on the bottles and, you know, but then he goes on into what he himself characterized a number of times in the summation as my main point. So how, that to me is very different than Green.
In that sense, except that he devoted about 15 pages of the summation in this case to that defense, so it was a substantial portion of the summation. It was almost 1/3 of it. So in this case, what the appellate division basically did is rip those pages out of the summation, and the problem is that those pages of the summation were actively prejudicial when you look at the court's charge as given.
Thank you, counsel.
Thank you.
Good afternoon. My name is Anders Nelson. I'm here on behalf of Appellant Mauricio Altamirano. With the court's permission, I'd like to request to reserve 2 minutes, please.
Of course, sir.
Thank you. This court should apply a prejudice standard to cases in which the trial court's charge infringes the right to an effective summation.
Hasn't prejudice and harmless error been used pretty much interchangeably? I mean, are we
Yes.
talking about anything different here when you say that?
I think that they have been used rather loosely in some of these cases. For instance, Smalling mentions prejudice and harmless error and seems to do so interchangeably. And I think that the problem with that is that when we typically talk about harmless error, we're thinking of a Crimmins analysis or the analysis of whether the defendant would have been convicted and the effect of the error on the conviction. So I
Well,
would.
but again, I see a lot of similarity here. I'm not sure what your proposed rule is, but your co-counsel here has talked about, whether it can be said and we've said in some of our cases, whether it can be said that the summation would have been affected by the knowledge of the charge as submitted to the jury. So how is that really different from a reasonable possibility that it affected the summation and therefore the verdict? So that's the second is Crimmins and the first is what we've talked about in this context, and I don't really see any meaningful difference there.
I think that the difference, Your Honor, is that the second statement that Your Honor made went to the verdict and went to an evaluation of potentially what would the verdict have been. What would counsel have argued in an effective summation? What would the jury have done? And that is an analysis that I think the lower courts have not been willing to do. The way that I read Green saying that when this court says, in the abstract, we don't have to consider whether the defendant would have been convicted, I read that as eschewing an analysis of what the verdict would have been.
But can't you also see it as sort of a presumption? If it meaningfully affected the summation, then we have to assume that it may have meaningfully affected the verdict.
Yes, if
right?
that's the direction, then yes, I would agree that this is the rule that we're advocating for. That prejudice results when counsel relies on the promise made by the court, tailors summation to that, and then the rug is drawn
Yeah,
out.
but I think you may have misunderstood Judge Stein's final question. I thought you were not taking the position that the standard is that the court's charge, whether it's giving a charge that they said they wouldn't give or not giving a charge they said they would give, let's just say that, affects in a meaningful way the summation choices, the strategic choices about how to proceed with summation by defense counsel. But I did not think you were advocating that somehow the standard requires that one connects the summation to the verdict itself.
No, I think the way I understood Judge Stein's question was then
Maybe I misunderstood her.
that there was an assumption that the verdict was affected. I believe that was the phrasing, and so that's how I was interpreting that. Then
So that's
essentially,
the standard you think, that we would assume that if the summation is materially affected, that then had an effect on the verdict?
I would say that then we're not looking at the effect on the verdict. That's the standard. I'm not advocating here that this court pronounce a rule where the appellate courts have to consider what the verdict might have been. That's.
So then how is prejudice, as you define it, different, if at all, from prejudice under the Strickland standard for effective assistance?
Under the federal Strickland
Correct.
standard? So the federal Strickland standard, you again are looking at whether the likelihood of the defendant being convicted, but for counsel's ineffectiveness. I would advocate more towards the New York standard for ineffective assistance that your Honor was discussing earlier, regarding meaningful assistance, which does have a prejudice component, or this court has at least said that it would be skeptical of an ineffective assistance claim where there would not any prejudice.
But we've been clear, it's different from the federal, otherwise it's exactly the same, because certainly you're prejudiced. You are prejudiced if it's not meaningful. I understand the point you're trying to make with that, but we have said that there is a difference. I'm just trying to see if you can articulate for me what the difference is with respect to your standard.
So I think we're using prejudice in a way that's different from the way it's used in federal ineffective assistance. The prejudice here is fairness, right? It's unfair for instance, in this case, for counsel to basically, in reliance on the courts saying it's not going to charge temporary and lawful possession, to give a summation that's tailored to that, then the court gives temporary and lawful possession to the jury.
But isn't the problem really in applying an ineffective assistance standard in a context which we've never applied it before? I mean, you could say where there's an objection, the court sustaining objections to a summation or limiting in time, that it's ineffective. Are we going to apply an ineffective assistance standard to that summation because the lawyer was unable to complete the summation they would have made? I mean, I don't understand a context where we can look at the performance of the lawyer in that sense of ineffectiveness when it's so affected by the ruling of a judge. Where would you stop with that? Because any ruling of a judge is, in a way, going to limit the performance of an advocate.
The ineffective assistance is an analogy that we're making here. It's not...
The test doesn't really work, Strickland or our test. So what would the test be? It's assistance of counsel, right? So the argument being you have assistance of counsel, you go to effective assistance counsel. I understand that. It was an odd context in Herring when they used it, but it's never been brought to this level before. I don't see any case that's applying it in this way. So we would be doing something different here, and I'm trying to understand how we would do it.
Your Honor, I would submit that Green applies this standard.
You see, the question that I had asked counsel on Mairena is the same question here, which is, what is the analytical framework that we should look at this within? And it seems to me we have two choices. Per se reversal if there's error, if the court makes an error that affects summation, or a harmless error standard of review. If the court makes an error, then we look at that error and see if it affects your right to a fair trial. It includes the summation and the verdict, but ultimately, I can't think of another way to look at it analytically unless you can articulate one for me clearly, and I'm happy to consider it.
There is support for the notion that deprivation of a right to a fair trial is not subject to harmless error. So when we have a framework that requires that counsel be told what the charge is going to be, so that counsel can then be effective and give an effective summation on behalf of his or her client.
I get that argument. So then any mistake in the charge is per se reversible error?
No, because you have to determine whether there was prejudice in terms of reliance by counsel on the promise, tailoring.
So let's talk about that reliance here. What would trial counsel have said differently if the application to reopen his summation had been granted? What would he have said that he didn't really get to say the first time around?
Trial counsel
when
never...
I read that summation, it seemed to me that some of the points that would go to a temporary innocent possession claim were argued, even though the judge had told him, I'm not going to give you that charge.
Trial counsel never told the jurors that they could acquit his client if the jurors found temporary and lawful possession here. He never mentioned the fact that the district attorney would have an additional burden to prove beyond a reasonable doubt that the possession was not innocent. He never marshaled the facts.
I know people do that in their summations, but you know, it's always a fine line of is the lawyer taking over the judge's role of instructing on the law.
Sure. So he never marshaled the facts with regard to the factors under the temporary and lawful possession defense. He never.
Well, he did adopt the defendant's statement to the police, no?
That's correct. But he was never able to point out how those factors were supported by the statement. And then you have the district attorney making arguments that really first told the jurors that there was no legal defense to this charge. So you have summations that are given, and then you have this defense standing out here that the jurors, I would submit, likely didn't know what to do with because they hadn't been told about it. So that's the fairness aspect of this that I believe our proposed rule takes into account, and that I do believe that the court, if not under an ineffective assistance type framework, could ground a rule in the denial of a right to a fair trial.
Thank you, counsel. Thank you. Counsel?
May it please the court, my name is Thomas Ross. I represent the respondents in this case. Whether you call it a prejudice analysis or a harmless error analysis, when you evaluate these claims of ineffective summation, you should look to the error in light of the entire trial, which includes the evidence and the effect it may have on the verdict. Now, this court has pretty much already held that in Miller, Smalling, and Green when it looked to prejudice or harmless error in these types of an analysis.
Miller and Green don't seem to have any consideration of the strength of the trial evidence in them.
Yeah, well, in Miller, they said the summation wasn't effective because he wasn't apprised of a petit larceny charge that was to be given. But the evidence was still looked at in that it wasn't contested what the value of the property was. So you still looked at the evidence. You still looked at the effect that the change might have had on the summation and still found that it was harmless. So you didn't just see that there was something that the summation could have addressed but didn't, and therefore he was prejudiced and per se reversal.
Didn't really say, because the only difference between larceny in the third degree and petit larceny is the amount, and the amount was not an issue in that case. There really was no difference in the charge, in the way that the lawyer would have, the defense counsel would have argued?
Well, not necessarily, because oftentimes when you know that you're getting a lesser included offense, you'll argue that, hey, if you're not going to acquit entirely, then you have this lesser included offense. So in a sense, he was prejudiced in that respect, even though it hadn't been in his summation, he hadn't challenged the value of the property, and it hadn't been an issue at trial. So I disagree. I think Miller does look at, it still looks at the effect. It looked at the harmlessness of this particular type of error in the context of a summation.
Why is that prejudice or any different depending upon whether the charge was proper in the first instance or not?
Well, it is a factor, and...
Why? I mean, what difference does it make? If we're talking about reliance, if we're talking about how the judges promise to charge or not charge something and then reverse without notice, how that affects how the lawyer argues on behalf of the client, what difference does it make whether that charge, especially if it was given and the jury heard it, should or shouldn't have been given in the first instance?
Yeah, you do look at the reliance, but then you look at the reliance, like say, in the context of the whole case. And if you look at the Mairena case, what the reason that the defense sought to include the box cutter in the manslaughter is because they didn't want the prosecutor to argue that if you found that he fell on, that the broken bottles caused the fatal wound, that they would convict. But you look at the evidence was overwhelming that broken bottles didn't cause it. And the prosecutor never argued that you could find guilt if you find that a broken bottle. In fact, they call it the phantom broken bottle theory. There's no evidence, just denigrate it entirely.
There was some evidence from the initial trial that some jurors, at least, may have been confused about that, right? That was the basis for defense counsel asking for the specific instruction the second time around.
That was, well, he had addressed that itself in the first trial. As I recall, the confusion was over the justification charge. But in any event, the first trial was 11-1 for conviction anyway. So it sort of shows almost twice that the evidence here was just overwhelming. There was just no way that the jury was going to find that a cut on broken bottles was the cause of death here, because, like I say, the evidence was overwhelming. If you look at the testimony first you have the testimony of the crime scene detective. He examined the area where Miguel fell, and there was no glass there. In fact,
So if I'm understanding your view
Yes.
of the standard, it would be that a court has to say there's nothing that defense counsel could have said to change the verdict, in summation.
that's part of it, yes, but also just the fact that it addresses some minor issue, or the evidence is overwhelming that it couldn't have changed the verdict, or like I say, even if the evidence wasn't overwhelming, it was on an issue that wasn't contested, or that was just
That sounds more like perhaps what Judge Wilson was asking before
Yes.
about the materiality of.
yes. Yes,
the
it has to
error.
be material, there has to be some sort of substantial reliance on it, so that it would
But
have.
it does seem like your rule boils down to, it doesn't matter what defense counsel could or would have said if they had known what the judge was or was not going to do.
No, you do.
That would have affected that jury. They would not have come out any other way.
No, you do evaluate what the judge could have said. But if you look at these two cases here, what could defense counsel have said? In the Mairena case, he already argued that if you find that he fell on a broken bottle, you have to acquit. So what more was he going to say? And like I say, the prosecutor said that if you find that there was just no evidence that he found.
So let me ask you, with respect to our ineffective assistance of counsel
Yes.
jurisprudence, does harmless error apply to those cases?
Under the federal standard, yes, because.
Under our state constitution?
The state constitution, no, it does say that, it does talk about prejudice in respect of denial of a fair trial, and they cited Benevento for that. But Benevento also says that the effect on the verdict is still a relevant consideration. And then this court went on to say in People versus Stultz that it would be very skeptical of any ineffective assistance.
So then is your answer that yes, that jurisprudence means that harmless error applies to ineffective assistance of counsel claims?
Well, yes, because as Justice Garcia was mentioning,
Wouldn't we have just used those two words, if that's what we really meant?
yeah, just say harmless error.
As opposed to the kind of dance back and forth in these cases about not adopting the federal standard, our standard is more generous or plaintiff-friendly.
But it's not
Defendant-friendly,
necessarily
excuse
just tied into ineffective assistance of counsel, because, judges make rulings on summations all the time. A defense lawyer might want to make a particular point, and the prosecutor objects, and the court sustains that objection. The defense can then.
But that is a little bit different, no, than knowing before you begin your summation, and you're crafting, right, sort of
That's-
the way you're going to proceed in that summation.
That's still, but if you're still prevented from making a particular point that you want to make, and you can on appeal say, I wasn't able to make an effective summation because I wasn't able to say this, or or let's say the judge restricts how long a lawyer makes a particular point, because.
Yeah, but their position is not that it's a per se error. Their position is that it has to result in less than meaningful representation. It has to fit within some framework that we've already identified.
Right, but it doesn't fit into the context of evaluating a summation very well, because like I say, if you just take
But how
out
does
the-
harmless error do it any better?
Well, you still, if you were just evaluating like a restriction on summation, not dealing with charges, you would look to see if the trial court abused its discretion in imposing that kind of a restriction. And when you look at the abuse of discretion, well, did it make a difference in the outcome of the case? And that would look at, how strong was the evidence, what issue was that particular point addressed to? You look at it in the entire context of the case. And it's
Can I ask
just,
you something specific about Altamirano?
yes,
So as I understand it, the appellate term said this is an error,
yes.
but said, however, it's not reversible error because you shouldn't have gotten the charge in the first place. Why doesn't that run afoul of LaFontaine?
LaFontaine, hadn't thought it in that regard, but it was, well, so in other words, the appellate term shouldn't have addressed that particular issue?
Well, they're affirming the conviction on a ground that was not decided adverse to the defendant.
Yeah. They still found error in the fact that the defense attorney wasn't able to reopen the summation.
Correct. So they found an error, and then they said, however, we're not going to reverse because of a different issue. That is, he shouldn't have gotten the charge in the first place, but he did get the charge.
Well, he did get the charge, but looking at the fact that he wasn't entitled to the charge in the first place goes to harmless error, because, he couldn't have been harmed if he
but it's a
was.
legal determination that was not decided adverse to the defendant in the lower court.
Yes. Well, he had asked for the charge, and that was determined adversely to him
No, it was determined, no, he got it, right?
initially, or at least the part where he was reopened summation was decided adversely
So
to
the
him.
error that's at issue is the declination of the request to reopen.
Yes.
Not the charging issue.
Yes.
All right, because I'm having a little trouble following, Mr. Roth. If you could just articulate the rule that should be applied in analyzing this case, without getting into how that rule then applies in these two different factual scenarios. If you could just give me your version succinctly of the rule.
You should look at what kind of reliance that the defendant had on the particular charge that either was or was not given, and determine what the attorney could have said or maybe would have refrained from saying, and how that would have affected the verdict, looking at the entire...
Isn't that the same as what has been talked about in terms of a material reliance, or isn't that
Yes.
really what you're saying?
Yes, the reliance
You're not saying
has-
that any reliance on some trivial matter, you're saying there has to be a determination. I'm going to go back to the Crimmins standard,
Yes.
Reasonable possibility or probability that it would have made a difference, essentially.
Yes, it should make a reasonable probability, because here we're dealing with just, an error in its statutory under 310 sub 4, which is what we're dealing with in this case.
Well, but doesn't this all come from Herring, that says that the whole problem here is that it affects the right to counsel, which is a Sixth Amendment error?
Well, Herring just deals with the entire deprivation of a summation. Here we're dealing with where you have a summation and what's the effect on that summation, whereas Herring, like
How
Herring...
about our cases where we said the failure to notify of a lesser included is prejudicial? That's a statutory error, right?
Yes.
So what's the difference?
Well, prejudicial, you still look at the effect on the verdict. They didn't describe in Smalling whether that was a reasonable possibility or a reasonable probability of effect. But nevertheless, you still look at what the effect is on the verdict, and it should be the reasonable probability, because this is a statutory, and it's not, even though it's related to the effective assistance of counsel, it's not a pure effective assistance
So you're
claim
saying in
itself.
both of these cases, there's no constitutional deprivation dimension?
No, it's just statutory error, and that it wasn't apprised
That's your
of the
argument.
particular charge. And 310 sub 4, yes. Yes. And in each of these cases, it was harmless. Turning first to the Mairena case, I've talked about the primary reason he was prevented from, they wanted to prevent the prosecutor from arguing that broken bottles would be a finding
Let
of
me
guilt.
ask this. If there was a constitutional dimension, would you come out differently in it?
No, you would still look hard.
you're saying
It'd just be like a reason.
Just so I'm clear, I want to be clear about what you're saying. So if there's a harmless error analysis applied, and if we apply the reasonable possibility of effect on the verdict, if you're given the wrong charge, that you still come out that there was no error here.
Yes, it'd still be, even though.
I'm sorry, it's harmless error.
It would still be harmless under the constitutional reasonable possibility standard.
Counsel, do you care to devote your remaining time to the justification issue, or your preference? Just reminding you your time.
Certainly. First of all, the remarks you made were not necessarily improper, because if you compare the facts of this case to the facts in sight, site, there was a duty to retreat, even though the victim had actually retreated and come back. So what he said wasn't necessarily error. In any event, if you accept the defense position that the duty to retreat wasn't until the imminent use of deadly physical force, and that didn't happen until Miguel was charging at him on the third. All of what he said, not all of what he said, the following didn't apply to that, but the fact that he could have retreated to Arismendi's help, that he could have retreated into the restaurant, and most importantly, could have retreated to the police car, which everybody knew was on the block right then. He could have easily retreated there. So that wasn't improper. The charge itself was
Does it matter whether he knew that the victim had or hadn't dropped the machete in between what has been referred to as the second confrontation and the third confrontation?
Well, you don't know for certain that he dropped, but he was...
Does it matter, or does it matter if we don't know that it's certain that he dropped it, but does it matter whether he saw that there was a weapon being displayed?
No, it doesn't matter, because when Miguel charged at him, he had stripped off his jackets, whereas he didn't do that before. So all he had was just a very thin, short-sleeved shirt on, which he couldn't have used to hide weapons. Plus, he went after him with his fist, so he had no weapons in his hands, and he wasn't reaching for his pants. He wasn't reaching anywhere else for any kind of a weapon. Plus, he had... certainly, just apart from that, he had an opportunity to retreat, because if you compare the second incident with the third incident, when he did retreat, when he was attacked by the machete, they were much closer together. Miguel was significantly further away from him on the third one, and yet he stood his ground and basically prodded him to come. The fact that the defendant prodded him into coming showed that he was not in fear of deadly physical force. And in fact, you don't even get to whether the duty to retreat under imminent...
So is that boiling down to if twice you're attacked, you should leave instead of waiting for the third time to come around?
Well, he should have left. Like I say, if you accept the defendant's,
Yes.
even the defendant was saying the second part was over. After Eddie Rodriguez dragged him, it was over. So now we're in a brand new situation. And then this situation, it's almost irrelevant what happened in the first two. He had a chance to retreat, and he could have, and he didn't. And like I say, you don't even get to whether he had a duty to retreat unless he had a reasonable fear that deadly physical force was going to be used against him. And that just wasn't the case, because at the time, even if he didn't see him drop the machete, Miguel didn't have the machete. And Miguel was only attacking him with his fist, which is simple physical force, not deadly physical force. And like I mentioned, he had a sufficient enough difference where he could have ran away, it's particularly since he was able to run away from the second incident.
Thank you, counsel.
Thank you.
Counsel?
So not to compare these attorneys to Clarence Darrow, but you look at the Leopold and Loeb trial, right? And in that case, it was the summation that saved Leopold and Loeb's life. You had two completely dead to rights child murderers, confessed child murderers. And it was a very unconventional summation that really focused on things that we wouldn't normally think of as being the focus of a summation, because weird things happen during summation, and arguments that we don't expect can change people's minds. So to say that there's nothing counsel could have said that would have changed anyone's mind, I don't think that that's the standard that can be applied to summation situations. And, I'm thinking about the effect on the verdict, and we're talking about, should we look at whether this affected the verdict?
Well, the consequences would be if nothing can be said to change anyone's mind, then why have summation?
Exactly, at all.
Why not just present the facts and let the facts speak for themselves?
Exactly, which is what Herring was getting at. And when you think about the effect on the verdict, I was thinking about baseball. I was thinking about if you get to the end of the game and one team says, all those home runs we hit, all of them are now worth 6 runs. Actually, none of them were worth 1. We wouldn't say, well, it's okay because that team would have won anyway. We would say this game is completely unfair. And that's because of something we learn when we're children, which is that you can't change the rules of a game at the end of the game. And that's what happened here. You had the judge here change the rules of how we were operating in this trial after counsel had said his final words. And that's what makes this not a fair trial. And that's what makes this a prejudice standard and not a harmless error standard, because prejudice looks at the fairness of the process as a whole. And what happened here was not fair. And it's not how we want trials to operate. And the fact is, this is the third time. This is the third.
So how are
yes.
we distinguishing between the point when it's not fair and when it's just an interruption, another error that we might say, that's really collateral? It has minimal, if any, impact, not just on the verdict, but even on what the counsel would have chosen to do in response.
And that's whether counsel relied on the promise. I think that's the standard. When counsel hears a promise and relies on it, and then that promise is broken, we can infer that counsel would have done something different in making those strategic choices.
How do you determine reliance?
You determine reliance based on factors like, did counsel request the charge? What did he object when the charge was over with? Were his summation arguments tied to the charge? I think those are the factors we look at. And the fact that this is the third case that has come before this court in the last 2 years with this issue shows that this is contagious in the lower courts and that this needs to be remedied because it's not a fair thing that's going on.
Thank you,
you.
counsel. Counsel? Excuse me.
Counsel, could we switch sports analogies for a second? This recently, a commentator described state and federal constitutional law as saying you get 2 free throws. Why would you only take 1? Why would you only argue the federal constitution when you could take 2 throws, 2 points? Did you argue the state constitution at all in any of these cases?
Your Honor, I believe that we've cited the state constitution. I believe that those aspects of constitutional law that are implicated in the case, are essentially identical, except for the kind of Strickland analysis that we were talking about earlier.
You didn't argue the PJ video factors or anything like that. You didn't address those.
I don't believe so. I don't believe
So our decision here would essentially be under the Herring line of cases, the federal constitutional standard.
Yes, and the extent to which I think the statute here that's at issue 300.10 implicates the rights that we've been talking about and the rights that Herring secures. So to cast this as just a statutory error really ignores the fact that the whole purpose of the statute is to ensure that counsel is able to prepare, that to ensure that the trial court's promise is final, and to ensure that something like what happened in this case,
Just to be clear, 'cause I want to be clear with what you're saying now.
Sure.
Are you saying that the argument that is preserved was based solely on the federal constitution, or was a constitutional argument without saying it was federal or state?
Preserved at the trial court level
Yes.
was a constitutional error generally under
With
federal
no
and
reference
state
to the federal or the state?
Correct.
Just the constitutional error?
The manner in which this was preserved was that counsel asked to reopen his summation to re-argue to the jury the defense that was given. So I would submit that encompassed both the error under both constitutions.
Okay.
I just want to, again, get back to, I think that the district attorney suggested that Miller and some of this court's cases talk about the effect on the verdict of the court's error. Miller does not talk about the effect of the verdict. Effect on the verdict of the error. Miller looks at what counsel did argue, as Judge Wilson pointed out. The charge that was given, the lesser included, ended up being irrelevant. Counsel would not have changed his summation, but that's what Miller looks at, whether or not counsel would have altered his summation, knowing what the court's charge would have been. And so that, I believe, is instructive here. I think that Green also sets forth a harmonious standard where this court again said, we don't have to decide in the abstract whether there would have been a conviction because there was prejudice, because there was unfairness in the process that was not something that this court wants to endorse, and not something that the lower courts should be, incentivized to potentially engage in.
Thank you,
Thank
counsel.
you.